You believe your doctor was careless, causing you significant harm and injury. But you are the only one who believes that he did something wrong. The doctor, on the other hand, says, I did nothing wrong. So it's really a he said, she said situation. Does that really rise to the level of medical malpractice? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Today I'm walking through the neighborhood. I'm walking the dogs. My daughter's here with me. Say hi, Mia. And I wanted to share this great information with you. You know, sometimes we get calls from people who say, I think that the doctor did something wrong. And now we say, what makes you believe that? And they give their recitation or their version of the events where they believe something was done wrong. And they believe the doctor did not truly appreciate what they had to say. So, is that worthy enough, or does that rise to the level of a medical malpractice case? Well, if you have a scenario where it's a he said, she said scenario, it's very difficult to prove a case just on that basis alone. Why? Because now the jury ultimately, if the case goes to trial, will have to determine who they believe is telling the truth. Is it the patient who claims they were injured because of whatever the doctor did? Or is it the doctor who claims he did nothing wrong? It then becomes a credibility match, and that's never a good position to be in. We want to be able to say, hey, listen, the doctor violated the basic standards of medical care, and as a result, you suffered significant harm and injury. I'll give you a perfect example. Let's say it's a lack of informed consent claim, where the patient says, the doctor didn't tell me about the risks associated with this procedure. The doctor turns around and says, yes, I did. What are you talking about? Now, assuming this was not recorded, assuming it was not videotaped, we simply have the patient's word compared to the doctor's word. And now the jury has to decide who is more credible, who is more believable. Do they believe the patient who says that the doctor did not tell them about the risks of the surgery? Or are they going to believe the doctor who said, listen, I always tell my patients about the risks of surgery. I tell them what the benefits are as well. And, you know, I don't remember exactly what I said to her, but I'm telling you, I did tell her the risks. This is my custom and practice. I've been doing it for 30 years. Who do you think is more believable? The reality is, it becomes extremely challenging, very difficult, to prove a case, to show that we are slightly more likely right than wrong than what the injured patient is saying in that scenario. Then it becomes a he said, she said scenario, and that's never a good place to be. Instead, we want to be able to show definitively that the doctor violated the basic standards of medical care, causing you significant harm and injury. We don't want to be in a situation where now the jury has to rely on credibility to decide who they like better, which personality do they like better, because once that happens, now we're at a distinct disadvantage. There we go. So why do I share this quick information with you? I share it with you just to give you a sense of what really goes on in these medical malpractice cases here in New York. You know, I realize you're likely watching this because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you have not yet started a lawsuit, but still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.